Welcome back to Toronto Speaks Legal Advice. I'm your host, Natalka Falkmer. We're joined today by one of Toronto's prolific family lawyers, Andrew Feldstein, and we're answering your questions about your alternatives to divorce court. Of course, we're also looking for your calls. We want to make sure that we help you tonight. So if you have any questions about family law, whether it be custody, support, payments, divorce versus separation versus common law versus marital relationships, we have the answers here for you tonight, so give us a call. Andrew, we're going to get right back into it, and we'll start with the basics, the 101, and sometimes I find the most confusing area of family law, which is what's the difference between a common law relationship and a marriage legally? What is the difference? Does it really matter?
The answer is yes, it does matter, and there are some really significant differences that people don't necessarily appreciate. I'm going to start with first, you can't be common law until you've been living together for 3 years, or you're in a relationship of some permanence that resembles marriage and have a child together.
But you must have a child.
If you're less than 3 years.
If you're less than 3 years, okay.
Then you have to have a child.
Okay.
Otherwise, you need to be together 3 years.
Okay.
Once you hit that period of time that you're at 3 years, a common law couple or a married couple have the same rights or very similar rights as far as spousal support is concerned. They will have the same rights as far as child support is concerned.
Okay.
However, when it comes to property and possession of the matrimonial home, that's where it differs.
Okay.
To begin with, a married couple, either spouse has a right to possess the matrimonial home. When they're a common law couple, that's not so. If one person owns the home, they own the home. The other one does not have a right to possession of the home.
And they could just kick out the other person, the relationship is over, you're getting out of here, I own this house? That's what can happen in a common law relationship?
Basically.
Okay.
There are certain technical arguments you can get into that aren't really worthwhile getting into today because it'll just complicate things. The other significant difference deals with property. A lot of people assume when you're married you get half. In Ontario, we live in a place where it's called an equalization of net family property. And in the simplest way, it means you share the increased value that has grown between both parties during the course of the marriage.
Okay.
If you are common law, you do not have a right to that equalization of net family property, but what you do have a right is to argue that it was a joint family venture that therefore gives rise to your claim over some property. A
joint family venture. So explain exactly what would be an example of that?
Well, it's something that was created, the term joint family venture was created by the Supreme Court of Canada in the last few years. Before that, we would argue about whether or not there was a beneficial interest in assets. And the problem is, it's trying to show that people had a joint family venture to carve out what that beneficial interest ought to be. And I always believe extremes set up the greatest example. So if you have a relationship that is 25 years and the woman stayed at home, and I know I'm being stereotypical when I say that, but I'm giving it as an example, the woman stayed at home, the man went to work, the man makes $200,000 a year or $300,000, and the man has all the assets and the woman has no assets. Mm-hmm. I would think most likely the court is going to say there will be a joint family venture and give her close, if not the same, as she would have been entitled to for division on that family property, because that's a long-term relationship that's clearly joint family venture.
Yes.
Compare that to a 30-year-old and 26-year-old who are together for 3.5 years and have no children, and they both worked full-time and had separate bank accounts, had separate credit cards, and really didn't commingle anything other than they each paid half the rent and they each paid half the bills. In that scenario, if one side had more assets than the other, I don't think a court would be very quick to find a joint family venture.
I see. So that would change how the calculations are done as far as support.
That's, well, spousal support.
Spousal and division of assets as well?
Spousal support would be the same whether you're married or not.
Okay.
But you wouldn't get your equalization payment, and I don't believe a court in the second scenario would find there's a joint family venture,
okay,
and you wouldn't get any property claims then.
Okay, got it. And of course, if you have any questions about this, please feel free to give us a call. We're here to help you today. Now, there's always seems to be a fight over certain aspects, like, you know, my inheritance. This is something that you frequently see before people get married. They want to sign contracts that protect that. Their rights to maybe the matrimonial home, and they want to protect that as well. Can you explain whether or not someone can opt out of having including, or rather having any access or right to the value of the matrimonial home, or access or right to one of the spouse's inheritance and so on?
Well, let me explain some of the background to this. First of all, you can enter into a marriage contract or a cohabitation agreement for people who are living together. And that deals with can deal with your rights for support and property, but not possession of the matrimonial home. So it can deal with ownership, but not possession. The problem you face in these contracts is the more one-sided they are, the greater the probability that a court may set aside that agreement at a later date. So you have to be aware of that, and you need to give full disclosure when doing a contract. Now, when you ask me about the matrimonial home, and can you say, for example, one person has it? Yes, you can say that as far as ownership, but not possession if you're married. If you're common law, you can contract both for ownership and possession.
Okay.
Now, you also talk about inheritances, and we get into a lot of fights about inheritances. And the reason for that is most people, when they get an inheritance, intuitively pay their mortgage down, finish a basement, do improvements to their home, put in a swimming pool. And the problem is the Family Law Act says if you get an inheritance, you have to be able to trace it to the date of separation. And in that tracing, if it went into the matrimonial home, you lose it.
Exactly. And then that's something that people need to understand, is that if it goes into the mortgage versus the furniture, it would be a different scenario. But the mortgage itself is something right into that home, to the value of the home, that it can get lost.
It's gone, and we frequently have arguments. Was it a gift from my parents of $100,000? Or did my parents lend me $100,000 so I owe it to them?
And we're going to have to talk about the difference between lending and a gift. But before we do, we have a caller who's patiently waiting, and it's Marion. Marion, go ahead, please.
Good evening, Mr. Feldstein. I have a few questions on you.
Sure, go ahead.
Let me get into situation. My pleading was struck, and then they could proceed with motion without notice. Okay. And they did, but on this motion without notice, they were amending application for spousal support. I don't know how they got this number, but they got some number, and it was based on value of my pension, that was actually 3 times higher than actually value was in this time. But my question is, how is it possible that any judge can approve value of the pension 3 times higher than actually was in this time?
Okay.
First question. Second question.
Marion, we're
how
going
is
to
it
stop
possible
you. Marion,
that somebody
Marion,
can get
Marion,
100% of
Marion,
pension?
sir, we're going to stop you right there. Let's answer that question, Marion, and then we're going to move on to your next question to make sure we answer everything correctly and in full. So first of all, can a judge order a spousal support based on a higher valuation?
Well, we have to start with, Marion said something right at the beginning of his question. His pleadings were struck, and a lot of people may not appreciate what that means. Pleadings can only be struck when a judge has made a court order and someone has breached that court order. And it's a very, very rare case where pleadings are struck. Usually there's been at least 1 or 2 warnings that someone needs to come into compliance with the court. I suspect that Marion probably either failed to pay costs, failed to pay support, or failed to pay, or I should say failed to provide court-ordered disclosure. Okay. Would that be correct, that the court found that you were in breach of a court order?
If I will, it was case conference. If I will not pay $2,500 for cause of case conference, they can proceed with motion without notice, and pleading will be struck. How could I have $2,500 and it was case conference? What I believe is against the law.
So what is this? Well, okay. First of all, let's explain what this case conference was, and then it sounds like Marion, you were requested to pay something. So perhaps Andrew, you can enlighten us on that.
A judge can exercise discretion that one party needs to pay costs to the other. At a case conference, a $2,500 cost award is a significant cost award. Judges under the rules can make orders at a case conference. If Marion did not like the order that was made, his choice would have been to appeal that decision to the next court above it. If it was at the Ontario Court of Justice, then Marion could appeal it to the Superior Court of Justice. in order to have his pleadings reinstated. If Marion did not appeal that decision, then he's stuck with the striking of pleadings. And when your pleadings are struck, it means the other side gets to proceed without Marion being present.
Okay. Is that what happened in this case?
That's what it sounds like, is
Okay.
they proceeded because, if I'm right, they may not have had the evidence of Marion's pension, and they may not have had all the evidence as to Marion's income.
Marion, did you provide the information necessary during this time period?
No, what I'm trying to explain, my pleading was struck on motion without notice. That is the law, family law rules, rules of civil procedure. Each motion without notice has to come back to the court. It never happened. It wasn't on motion, it was on motion without notice. That is the law, that each motion has to come back to the court. It did not happen.
So, sorry, go ahead,
Okay,
Andrew.
what Marion's referring to is a rule that says if there's a motion without notice, it has to come back to court within 14 days or such other date as determined by the court. But Marion said earlier that he was required to pay the cost of $2,500 and he failed to pay it and his pleadings were struck. When your pleadings are struck, the other side, pursuant to the rules, gets to proceed without any notice to Marion, and therefore that motion does not have the requirement of coming back within 14 days. The same way, I'm going to give you an example. If I'm worried that my former spouse is going to take my children and run to another country, I may run to court tomorrow morning and ask for an order that stops her from leaving the country with my kids, and I may even ask for her passport to be surrendered. The court is always concerned about granting orders when the other side isn't there to tell their story.
Yep.
So when that happens, they say the matter has to come back to court within 14 days.
Okay.
Which is very different than when somebody's pleadings are struck, which means they had their day in court, their case has been thrown out, and now the other side gets to proceed without any more notice. That's what pleadings being struck means, and there's no requirement to come back in 14 days.
Well, and Marion, I want to help you with this one, but what are Marion's options?
Marion needed to appeal the order that was made striking his case, and he had to do it within the timelines of the rules. His other option would be to bring a motion to set aside the order striking his pleadings and to set aside the final order against him with respect to support. Now, without looking at the minutiae of the case, it's very, very difficult to give any type of opinion on it because it is rare for courts to strike pleadings, especially at a case conference. So it makes me believe that Marion obviously took some positions that the court looked upon as very unfavorable, because from my experience, I do not recall pleadings being struck in any cases I've ever appeared on at a case conference stage, because that is a stage where judges would rarely make that kind of order. And a cost award at a case conference of $2,500 is an extraordinarily high award at a case conference, because a case conference is meant to be settlement oriented rather than litigation oriented. So some things happened there that I don't believe are coming across in full right now.
And unfortunately, Marion, we do have to let you go with that. So there are some options for him to move forward, but of course this means that it also shows how you have to be very responsive and make sure that you abide by some of the court orders. And we do have to move on. I'm sorry, Andrew, to the next one. Marion, thank you so much for your call. We do invite some more people to give us a call to see if we can help with your family law matters.